Hey folks, and welcome to a quick update on the income store situation. If you are new to the channel or new to the developing income store story, instead of just going and giving you the whole background on what's going on, I just suggest that you go and check out the playlist that is in the description below in this video, and that will give you all the background that you need to actually understand what is going on with this video. Alright, so here's what we are going to cover. Are court rights attorneys quitting his cases? The United States motion to intervene in the civil case, the motions to dismiss filed in the class action suit. All right, we've got a lot to cover, so let's get to it. First up, in the civil case, it looks like Kenneth Courtright's attorneys have moved to withdraw. When I say withdraw, I mean they are no longer wanting to be Ken Courtright's attorneys in this civil case with the SEC and TGC. Their motion was filed today, which is July 29th, and is fairly vague as most motions to withdraw are, as the attorneys still have the obligation of protecting their clients' information, private information, and secrets. The reason cited is irreconcilable differences having arisen between Courtright and counsel, making continued representation of Courtright unreasonably difficult. Certainly, that leaves plenty of room for us to speculate what exactly those irreconcilable differences are. Sometimes that's code word for my client is unreasonable. Sometimes that's code for my client won't listen to me. Sometimes that is code for my client can no longer afford to pay my bill. Sometimes that's code for we as attorneys can no longer manage and handle this case. Maybe it's too big. Ultimately, that's not something that is shared in this motion. So I will leave it to you to speculate what could possibly have happened, and I know that I have a few potential ideas for what this might be about. Next up, filed yesterday in the SEC case by the United States of America, they have filed a motion to intervene and to stay in part the civil proceedings. Now, they haven't moved to intervene and to stop everything in the SEC case. In fact, basically all they want to do is for the court to order in this case that the parties not hold depositions, meaning not do the on-the-record, under oath interviews as part of discovery. People can still request and exchange written documentation, and this is when it is interesting and maybe exciting when you see a criminal case and a civil case tracking along together on the same topic or about the same activity. A very clever defense attorney would potentially look at this as an opportunity in the civil case to gain information that they wouldn't normally be able to access in a straight criminal case, because the discovery rules in a criminal case and civil case are different. And basically what the government seeks to do is to hold off on doing some of the lawful discovery that the attorneys could do in the civil case until the criminal case has wrapped up so that the government can protect its witnesses and its case. The motion is 10 pages long, but I honestly don't think it's necessary to go through it unless you find this legally stuff really interesting. Basically just think of it like a chess game, like chess moves, and each of the party are making their moves in order to protect their case and also to even attack. Do I think this motion is likely to be granted? I do. They're not stopping discovery all out. The parties can still investigate their case in the civil case, and the SEC takes no position, meaning they're cool either way. This motion also comes at a tough time for Ken Courtright because his attorneys have just filed a motion to withdraw, so it is unclear to me when exactly the court will order on this motion to intervene, because they will give Ken Courtright some time to hire new lawyers, and that of course assumes that he can. It's hard to imagine that if the irreconcilable differences he had with his lawyers had to do with money, that he would be able to just go out and hire someone new if that problem has not been alleviated. And some other fireworks that I haven't covered yet are actually coming in the class action case. This is the class action against Heartland Bank and PNC Bank, and both defendants, Heartland and PNC, have filed motions to dismiss. Now, before people get up in arms about this and start worrying about what this means, please know that it is fairly common for defense attorneys and defendants in complicated cases to file motions to dismiss before answers are filed. Sometimes the end goal is to just make the pleadings more clear so that everybody knows what is happening and what is being pursued. Sometimes it's about trying to cut off the case before it goes too far. Sometimes it's about lawyers trying to churn the file to make as much money off a case as they can. The memorandum of law that goes with this motion to dismiss in both cases for both defendants are fairly meaty. And I think it goes beyond the scope of this channel to go through it line by line and explain the legal aspects. But one of the things that kind of cracks me up is how the defendant PNC calls Ken Courtright the fraudster. Two of the claims contend that PNC aided and abetted the fraudster's conduct. I think that might be the strongest language that I've seen in any of the pleadings. I should note that PNC and Heartland, neither of those companies is saying outright that a Ponzi scheme didn't happen or that people didn't lose money. The heart of their allegations of their motion is that they're just not responsible for it. As to what could happen as a result of this motion, it could result in one or both of the defendants being dismissed from the case outright, or an entire outright dismissal of the case, or it could mean that some of the claims go away, or that the plaintiff has an opportunity to clean up their pleadings and potentially make them better so that the case can go forward. I'm not sure when specifically the hearing is on this motion to dismiss, but I expect there to be more pleadings, more back and forth before we end up getting there to argument and a decision. And finally, in the criminal case, I don't see that there has been a lot of other outward progress. But if we look at the last hearing from July 21st, there was a telephonic status hearing, and that was actually continued, meaning postponed until August 21st, so that defendant could finalize his attorney arrangements. So it looks like Ken Courtright is changing over his attorney teams in both the SEC case and his criminal case. As to who is being brought on and how he is going to be financing these, I don't know just yet, but I'm definitely super curious about how he's able to make this happen when he probably doesn't have a lot of access to capital or his assets at this point. If you're following this story closely like I am, either because you are an investor or somebody who was harmed by this, you'll notice at the receiver's website that they set up to keep the investors and people harmed informed, there really seems to be a lack of concrete and solid updates as to what is going on in the case. And I just wanted to highlight the fact that I personally am not an insider. I don't have people from the inside feeding me information or updates about what is going on. I am simply going to the PACER website, that's the Public Access to Court Electronic Records website, and checking on these cases. And when I see information that I feel like I should share or could share, then I will come and make a video about it. So if you feel like you want to get better and more up-to-date access to the information, or even to read the pleadings that I'm talking about here in these videos, there's actually a video, and you should see it up in the corner, that is a tutorial about how you can directly access and go around me to get that information from PACER, from the Public Access to Court Electronic Records. You should see that box up there on the screen. As always, thanks so much for watching, everyone. We'll catch you in the next one.